I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are jumping into compilation number 195. We will be in 3 different judges' courtrooms. Before I give you those names, don't forget to like, comment, share, and subscribe. Commentary will be left in from when these previously aired. Also, chapters will be added for your convenience. Now, we will be in the courtroom first and foremost of Judge David O'Donnell out of the state of Ohio. Second, we will be in the courtroom of Judge Kathleen Lang out of the state of Indiana. And last but not least, we will be in the courtroom of Judge David Goggins out of the state of Michigan. Listen, let's keep this train going. This is 195. And let's go ahead, guys, and jump in.
Mr. Matthews, is that right, Ms. Bell?
That's correct, Your Honor.
All right. Mr. Matthews?
Thank you, Your Honor. I am in receipt of this additional evidence. I did mention in chambers that I do have some concerns about the admissibility of these images without there being some sort of sufficient foundation as to how they are generated and what they are actually showing. But aside from that, Mr. Burrell has just asked me to file his certificate of live birth, and I do not know the relevance of that, and perhaps, is that something you want to address with the court, Mr. Burrell?
Yes, Your Honor. I've been sick in the hospital for a couple of days. I haven't had a chance to really file the paperwork that I want to file to the court. I have a certificate of live birth here that's stating my status.
What's your status?
Alive.
All right, I assume you're alive since you're sitting here.
Okay, but you know, sometimes the courts assume that you're a corporate entity.
Are you a corporate entity?
I'm not.
Okay, I don't assume you're a corporate entity. I assume that you're Mr. Burrell sitting in front of me.
So,
So you want to file a certificate of live birth to prove that you're a person?
I'm not a person.
What are you?
I'm I'm not a citizen.
Well, you said, are you a person or are you not a person?
I'm not a person. I'm indigenous.
What does that mean?
I'm an American. I was born in this country.
Okay.
I'm not a United States citizen. I'm not.
What are you?
What a definition.
What do you have citizen? What are you a citizen of? Are you a citizen of some other entity?
I'm not a citizen of anything.
You're not a citizen of anything?
No.
Okay.
A citizen is a corporate fiction.
A corporate fiction?
Yeah, I mean, it's a definition. Okay. Like I said, this is the problem, Your Honor. Me and Mr. Matthews is having a hard time coming to an agreement about whether he's defending me or he's working with the prosecutor. We, a lot of this evidence and stuff that's been presented to the court.
Nothing's been presented to me because we haven't had a trial yet.
Okay, well, I'm sorry. What's been presented to me, he's under the impression that I'm guilty or that he sees things that he doesn't see. And I've been trying, it's like we can't, if he's representing me or here on my behalf, then
so
it's not showing.
Is it your position that you don't like how Mr. Matthews evaluated the evidence in this case as it relates to
not
you?
Not only the evidence, but just his whole attitude towards me, and period. Like, you know what I'm saying? It's clear I didn't have anything on me.
Well, that's why we have trials. The purpose of a trial is for 12 people to sit here, listen to the evidence, and make a decision as to whether you did or did not do what you're accused of doing beyond a reasonable doubt. If they find that you didn't do it beyond a reasonable doubt, then you're acquitted.
I agree, sir. But with that being said, there's things I'm asking him to do, and that it's my right for him to do, whether or not he believes it's okay. So if I ask him to file something into the clerk of courts, it's my right to file those things.
So he's not filing something for you?
Well, I just asked him to, and he's made an argument of it when it should have just been something he did.
What was it that you asked him that he won't, that he's
What I
arguing?
wanted him to, just to have it on the record, was my certificate of live birth, whether or not you.
I mean, what is that? Tell me, let's say that the certificate of live birth is filed.
Okay.
What impact does that have on your trial?
I don't know.
You don't know? Okay.
Not at all. But
Well,
I do want to know.
Mr. Matthews is under an obligation as a member of a lawyer in good standing with the Supreme Court to file things that are done in good faith and are relevant. I mean, you could ask Mr. Matthews to file a copy of your high school graduation certificate, and that has no relevance to this case, and he would be under no obligation to file it. So you want him to file your certificate of your certificate of live birth to show something that you, if just told me you don't know that it means anything.
Well, I
It's
know that
relevant.
it means something. I just don't think that everybody else.
What does
knows
it mean?
means something. I just want on record that I'm not a citizen.
Well, you just said you are a citizen.
I never said I was a citizen.
You're an American.
I'm an American.
Okay, so if you're not a citizen, what impact does that have on your trial for next week?
I just want it on record.
Okay.
It's not. I don't need any impact on the trial.
If you believe, okay, and if I believe that the filing of your birth certificate means you're not a citizen, what impact does that have on your trial?
I'm not looking for an impact. I just want it on the record.
Well, it's on
For
the
my
record.
safety.
It's on the record. You believe you're not a
Okay.
citizen. Okay, now what?
All right, and then also I asked
Well,
him.
no, wait. Let's take one thing at a time.
Okay.
You've put on the record, because she's recording all this.
Yeah,
okay,
I got that.
That you're not a citizen, okay? So now what should we do as a result of that?
I mean, I just want my indigenous rights.
What are
That's
your
all.
indigenous rights?
You haven't looked at them?
No, you told me you want your indigenous rights. Tell me what your indigenous rights are.
Well, I know I fall under a certain constitution.
Which
and not
constitution?
under these, the American Constitution.
Okay, you fall under the American Constitution, okay?
I believe so, yeah.
So I believe so too.
You know, the Pope put out a letter to the rights of the indigenous people. Are you familiar with that?
I don't care what the Pope says. The Pope has no impact on the
Okay, well, then
jurisdiction of
let's
this
move forward,
court.
Your Honor.
Huh?
Let's move forward. Whatever you decide. I also asked him for his oath of office and the prosecutor's oath of office.
Okay.
I have your oath of office. I just wanted to have those paperwork.
Okay.
From my
Anything
record.
else you want to say?
Nope, I'm here.
Okay, so we're scheduled for, we're going to have this trial, jury trial, January 20th at 8 a.m. And you will be provided the jury questionnaires like you normally are. And you've, unless you have changes to your trial briefs, I've already got those. And anything else that we need to discuss regarding this trial?
Nothing from the state, Your Honor.
Mr. Matthews?
No, Your Honor, thank you.
All right, then you guys, everybody needs to be here at 7:45 on Tuesday morning.
All right.
Your rights. I know my rights. I don't need an attorney. Yeah. Thank you.
Right, Ms. Matlin, you are here today for an initial hearing. Tender to the court has been filed, notice living man, declaration of status. Those are signed by you and have been entered. There's also an affidavit of truth that is unsigned. And so anyway, we're here for an initial hearing and to make sure that you understand your charges. What is your date of birth?
I do not understand. I am here on a special appearance of Thomas Maitland in all caps letters on a special appearance of the case number of 46D04-3602-CM-0250.
Correct. But I need to tell you what you're charged with in this case. So first of all, how old are you?
I'm 29.
All right, what's your birthday?
You guys should already know that, correct, or no?
No, I don't. I don't know what your
I don't
birthday is.
understand. I don't understand.
I just need you to tell me,
Here's the
court.
problem. If we don't know who you are, there'll be a warrant issued for your arrest. So we're trying to get past that level.
Okay.
Okay, so state,
Then you didn't get these papers. I'm gonna give them to you.
okay, so let's back up. My job is to make sure you understand what you're charged with. I have what you filed, and that's made a matter of record. What is your date of birth? Well, you know what? Let me see here.
I'm.
Okay, hold on. I do have it. Is your birth date 9/29/96 and you're 29 years old? Is that correct?
That is my living man. Yes, that's when I was born, but not this all caps name that's on the docket that you sent me papers for.
Okay, yeah, so your correct name is, I had that right here too. Well, you signed it, Bo Matlin, what you entered into the court.
Yeah, but not in all caps.
Okay, all right, that's noted for the record. We have an address of Lean, Michigan, and is that where you live?
I do not.
Okay, where do you live?
That's me, my person, not this all caps name.
Okay, I understand that. We made a record of that, so that's not a problem.
Okay,
But what I need to know is if that's where you live in Glean.
No,
That's not where you live?
that's where the physical man lives, not the all caps name.
Okay, the all caps name I've taken care of.
Okay.
Right, I understand your concern with that, taken care of, that's, well, that's noted for the record, that that's not the way your name is. But what I need to know is what your address, so that you can be properly notified of things that are going on in this court. So what is your address? Is that where,
Your Honor,
you live?
Your Honor and the prosecutor have taken an oath of office, correct?
Okay, this is not your time to ask, sir. Okay, so we have to make sure that we go through the right procedure. You filed all that, so I understand where you're coming from, so to speak. But what I need to do, I have a job, and I would be not upholding my job and what I am sworn to do if I did not inform you of these things. So I need to know if you live at Michigan.
That the
Okay.
living man does, not.
Okay, the
not
living
all
man lives
caps.
there, correct?
Not the all caps, there's two different.
Right, no, the living man lives there in Galean, correct? At that address?
I don't
All
understand.
right, when you go home tonight, where are you gonna sleep? Are you gonna sleep at this address in Galean, Michigan?
That's where I reside, but that's not where
Right.
this corporation of my all caps name is.
Okay, so we've got that's where you live, so to speak. Then I also need to make sure that you understand your constitutional rights. So do you know what your constitutional rights are as a defendant in this court?
Yeah.
Everyone, the Constitution gives you certain rights that have to be followed, as a defendant here. So do you know what your constitutional rights are?
Yeah, I state on record my constitutional law, section 329 is Chicago Motor Coach versus Chicago, Lagar Chicago versus Chicago, Lagar versus Chicago, 29NE934.
Okay, that obviously is not a case that would be applicable here because this is Indiana, but I need to make sure that you understand that you have the right to an assistance of a lawyer if you want one. If you intend to hire one, you have to do within 10 days. And if any deadlines are missed or legal issues or defenses that could have been raised could be waived or given up. If you're unable to afford a lawyer, the court will appoint one for you. You have the right to a speedy and public trial to the judge or a jury. And if you want a jury trial, there has to be a written demand with the court 10 or more days before the trial date. You have the right to require the state to prove the elements of the charge against you beyond a reasonable doubt at a trial in order to obtain a conviction against you. And throughout these proceedings, you are presumed to be innocent. You have the right to hear and cross-examine all witnesses appearing against you. You have the right to require witnesses to be present at any hearing or trial to testify on your behalf. And the court would assist you in that right by issuing subpoenas. You have the right to remain silent. You cannot be compelled to make any statement or testify against yourself at any hearing or trial. Anything you do say could be used against you. You have the right to be tried in the county in which this offense allegedly occurred. You have the right to appeal to a higher court if convicted. You have the right to demand the nature and cause of accusation against you and to have a copy of the information. If you plead guilty, you would give up those rights. Now, I'm not going to ask you if you agree with those things. I'm going to ask you if you understand what it is that I just read.
I do not understand.
Okay, what don't you understand? That was wrong.
Well, I mean, I just stated where I stand.
Understand, but
Understand.
okay, those are your rights under the Constitution of the United States of America, as well as the Constitution of the state of Indiana. I am not going to ask you if you agree to them. I'm not going to ask you if you think they apply to you. I just want to make sure you understand those are your rights, if you choose to accept them or not. Those are your rights in this country, in this state. Do you understand that?
I do not understand.
Okay. We'll make for the record that you don't understand that. Also, that those rights have been read out in court, and so that you have been apprised of them. So, State, could you tell the defendant what he's charged with and what the possible penalties are?
Your Honor, he is charged by way of information that alleges that on January 31, 2026, in LaPorte County, state of Indiana, the defendant unlawfully, knowingly, or intentionally operated a motor vehicle upon a highway, a Ford Ranger with Michigan license plates, D as in David, P as in Peter, T as in Tom, 9082, having never received a valid operator's license and not being exempt from those requirements under Section 9-1-4-27. That is a Class C misdemeanor. A Class C misdemeanor is 60 days in the LaPorte County Jail and a $500 fine.
All right, so Mr. Maitland, again, I'm not going to ask you if you agree with that or if you think you're subject to that law, which of course we've established that you are, but you understand what the state is saying that you did that's against the law. Do you understand what that is that they're saying, that you hadn't ever received a license?
I mean, he stated a statute. That's not law. That's not constitutional law. You just asked me if I understand my constitutional law, and I do understand my constitutional law. And what he stated is a statute that doesn't apply.
Okay, so let me stop you there. So the statutes are pursuant to the Constitution. We can have no statute that violates the Constitution of the United States or the state of Indiana. So you can make your arguments on the law. All I need to know is if you understand what the prosecutor said.
I do not. I do not understand.
Okay, so what the prosecutor did, the prosecutor read to you what they have charged you with, the state of Indiana, what they charge you with, and what the penalty could be for you.
Yes, ma'am.
So we're going to make a record that was read clearly out to you, and as the charge and the possible penalties, so that has been done on the record. I'm going to enter a preliminary plea of not guilty for you. And are you going to hire a lawyer, represent yourself, or ask for the public defender?
I'm going to represent myself.
Okay, all right, we'll make a record of that. I do need to tell you, however, you have the constitutional rights to represent yourself in this court. However, you will be going against the state, and they are attorneys who are licensed, who are very experienced, who understand the law backwards and forwards. I just need to make sure that you've heard me say that and that you understand that. But it is your right to represent yourself. So we'll make a record of that. And we're going to reset your case to, as given about.
I have a record to show that I don't understand the statutes that the state is putting upon me, and I don't understand where the constitutional law is coming from, because I'm stating the constitutional law, and you swore under an oath of office, and so did the prosecutor. So if you guys don't want to stand the oath of office, then we'll have to proceed from there.
Okay. All right, understood. Your next court date?
I just gave them a form vote to self-represent, just so you.
Okay, all right. So we got a form there, so you know what you need to do as a self-rep to represent yourself. And our next court date is
March 25th at 12:45.
March 25th at 12:45.
Thank you.
Yeah, that's okay. We gave it to them.
I know you do that one, sneaky. It's kind of mean. You gave it to the magistrate.
It is his.
Oh, okay, all right. I didn't make that up.
Call that last number, I was.
Oh, listen, ma'am, if I could do that at my will, he would get a lot more cases.
We're off the record.
Yeah.
Okay.
Order, Mr. Jamal, let's just do your second one, your Citibank versus John Hayes.
Yes, and good morning, Joseph Jamal here on behalf of the plaintiff.
This is file 2425, and I've got another gentleman here, John Michael, who apparently has filed paperwork.
Yes.
Mr. John Michael, you've got semicolon Hayes, respondent. First of all, are you an attorney?
I am not.
Okay. So do you have, you're alleging in, I guess, all these documents that you're somehow a representative for John Hayes. Is that right?
That is correct, sir.
So how are you, or it says beneficiary, do you have some paperwork giving you some authority to act for John Hayes today?
The UCC one that was filed.
What, no, is there an order, court order? I understand the rules and the statutes and the laws, but do you have anything that says, listen, you've got authority?
I have nothing other than the process of the United States Corporation
I
that
see.
committed started the trust in my name.
Who started the trust in your name?
The Corporation of the United States of America after its bankruptcy.
Oh, you went through a bankruptcy?
No, the United States of America, the corporation did.
Oh, I got you.
19.
So but you have
1933.
nothing that says you can represent John Hayes then?
I'm not acting as surety for John
Okay.
Hayes, that is for sure.
All right, so we've got a motion to dismiss. I don't have an attorney that's filed a motion to dismiss. I guess, Mr. Jamal, let's hear that first, I guess.
Your Honor, I guess my understanding, you said motion to dismiss. Is that for plaintiff's motion for summary
Yeah.
judgment you're referencing?
Well, you've got your summary disposition motion that's out, but he's got also, it looks like his motion to dismiss, defendant's motion to dismiss. That's one I think is probably easier to deal with first.
Okay.
I don't even know what it, quite frankly, it is, but you did respond to it, it looks like. Plaintiff's response to defense motion to dismiss. Anything you want to tell me on that one, I guess?
Nothing further, but for the fact that, based on my understanding of the court rules, everything was filed as required by the law. No actual documentation is required with notice pleading state, of which Michigan is. Notice was provided since we have provided detailed account documentation supporting our claim. So I think his motion to dismiss related to failure to state a claim and lack of subject matter jurisdiction should both be denied.
Okay.
I object
And
to
Mr. However you want to refer to yourself, John Michael.
John Michael, yes, sir.
Okay. What did you want to tell
I-
me about your motion?
Well, I asked all of the parties involved for validations, and I sent a statement of facts, and none of which were responded to. So that would be acquiescence to the truth of my statements, which should stand in truth and commerce. I asked for a contract and demonstration where there was adequate consideration giving, and did not receive any of that. It's my understanding that the consumer credit transaction or the application was taken by the Citibank and Best Buy to securitize the collateral to the Department of Treasury for their funds. They were paid, and now they're asking for me to pay in addition to that. I did not realize any of this was true until recently. And now if I am continuing to be required to make payment in any form of negotiable instruments, they are, in my opinion, are being unjustly enriched. They have never given me a contract with a signature. They've given me valid verification by bills and statements, but never anything that would demonstrate that they ever had anything at risk or that they lost anything.
Therefore, without a contract, there is no standing, there's no claim to bring remedy to.
You find there's been significant number of documents that have been filed, one being the motion to dismiss this matter. It's signed John Michael, Hayes beneficiary. I've got no indication that John Hayes, whose pleading this is filed against, is in fact here. I've got no attorney representing John Hayes. I've got some allegations that John
Sir,
Michael,
I do not
hold on,
believe
sir, it's
I
my
need-
turn. Sir, it's my turn.
right.
John
All right.
Michael is somehow representing John Hayes. That's one problematic point with the motions that were filed. It's got a notice of special appearance, but I can't have a special appearance without some authority from John Michael. I did get a chance to review nonetheless all the documentations with regard to the motion to dismiss. I reviewed plaintiff's response to that defense motion to dismiss. I do find there are a significant amount of documents that have been attached regarding this account that's alleged to have not been paid. It's a credit card account of some sort. All of the addresses match up to the same John Hayes at the same address, 5141 Flagler Street, Flint, Michigan, 48532. Statements were going to that address. I see the card or the account was used on that occasion, so throughout the documents that have been supplied. Also find that there were some payments made on that account as well. Therefore, based upon all of the evidence at this point, based on this motion to dismiss, that motion is denied. And now we're on plaintiff's motion for summary disposition based on MCR 2.116. Is it a C9, C10? I guess I gotta look. C9, C10 motion. Mr. Jamal, this is your motion at this point. What, on this motion, did you receive a response to the motion for summary disposition?
I did receive a reply from the defendant. That was somewhat recently. I'm not sure if the court has that in the file.
Okay, I got.
It's titled the reply. Let's have it opened here.
You should have it since it was filed at the courthouse.
What's it titled?
It's titled Respondent's Reply to Plaintiff's Response to Defendant's Motion to
Oh,
Dismiss.
I got that one.
Okay, that's the only one I see.
Okay. Mr. John Michael, is that the only response to the motion for summary disposition?
You asking me?
Yes.
Yes.
Okay. All right. I've got that.
That was the last response because that was I have not received anything more from them.
Okay. All right. So I've got that in my hand as well. Mr. Jamal, you can proceed with your motion.
Yeah, so the motion is primarily based on 2.116 C10. Included with our motion for summary, we've provided detailed account statements that breaks out the usage of the account from a zero balance to the balance we're seeking in our complaint. We show not only usage, but also payment made towards the account. Those statements were sent to the address we currently, I believe, service was made to defendant at. Given those facts, we are seeking a motion for summary be granted in the amount as requested. And I would just indicate too, defendant has referenced seeking a wedding signature, additional contract terms, etc. However, usage of an account constitutes agreement for liability on that account. These statements specifically indicate that this account was sent and used without objection by defendant, and therefore liability should exist.
Okay. And the amount, it looks like, just on the, I don't want the court cost, but it looks like the damages for the card, the account itself is $2,349.65. Is that the right amount?
That is correct, yes.
Yeah. All right.
And that should be supported by the last statement we have included in our packet. Also has a balance of $2,349.65.
So let's see that here. Oh, way in the back here.
The payment due date on that statement is February 17, 2025.
Oh, thank you, Jamal. I was just looking for the last, here it is. Yeah, I'm sorry, February 17th, 2025. That's the last one I'm seeing. Yeah. Okay, Mr. John Michael, any response?
Well, actually, kind of my paperwork should stand on its own. There was billing statements are self-generated and lack foundation and are inadmissible as live testimony and of a custodian with a personal and no one of personal knowledge under MRE 8036. Prior payments do not establish a contract liability. My my realization of the fact that the Citibank, Best Buy, and or the law firm have provided any adequate compensation to complete the contract, and nor did they express the fact that they were changing my standing from the creditor because it was my credit worthiness that created the substance for the loan. They were paid. That was basically conversion from me from the creditor to the debtor. Under trust law, it converts my standing from the beneficiary to the trustee. And I still I affirm that there is no standing that they have to file a claim against the living man. And if you're refusing to.
Mr. Michael, from what I hear though, you're acknowledging that this is your account.
I am not acknowledging that it is my account.
Well, you just said that they used your credit standing to form the basis of the contract originally.
Yes, that is true.
So how are you not?
Therefore, if it was my financing credibility that funded this loan, how do I owe them any money?
Sure, I quite understand, Mr. Jamal.
I'm not hearing you.
The only response I would have, Your Honor, is he does reference admissibility. I think Michigan law is pretty clear that when it comes to a motion for summary, documentation is admissible to the extent that it would be admissible at a trial with proper foundation being laid. Foundation does not need to be laid at the motion for summary stage. There is no need for testimony or additional authentication. So the statements are properly before the court at a motion stage.
Okay, I'm just going to take a brief recess off the matter. I'm going to review the statements that have been supplied. Nope, that's it. We're done. Nope. I'm going to make a decision. Hold on. I'll be right back on. Sir, you told me that already. I'm going to take a brief recess. I'm going to review all the pleadings in its entirety, and I'll come right back on. Okay, we can come back on the record with Citibank versus John Hayes. I've had a chance to review all the pleadings and documents that have been provided by both sides. This matter. This is a motion brought in part by MCR 2.116C10. This motion may be granted where there is no genuine issue of material fact and which would entitle the movement to a judgment as a matter of law. In determining the factual support for this claim, I have reviewed all of the pleadings, affidavits, any depositions, admissions, and other documentary evidence that's been provided today. It should be noted that the non-movement party, that being John Hayes in this matter, does not rest merely on allegations or denial of the pleadings, but also must demonstrate by documentary evidence that there is a genuine issue for trial. I do find after significantly going through all of the documents that have been provided to me today, the consistency of the statements that went out, starting with a new account through Citibank on this account, and this account was, let's see, where is it? prior to ending in 8271, John Hayes, you find that this card was used over a significant period of time. There were also payments made over a period of time. The address was sent, all of these documents were sent to, these statements were sent to John Hayes at 51. Do find it's consistent with what's been complained of, the amount owing. The final statement that has been complained of today, February 17th, 2025, shows a balance owing of $2,349.65. Find based upon all the documents, all the pleadings, there's no genuine issue material fact. Grant motion for summary disposition to Citibank for damages $2,349.65 plus court costs that are being requested. Mr. Jamal, I thought I saw somewhere in here.
There was a proposed judgment submitted with the motion.
Okay. Just gotta find it.
Everything's still in order. It's typically page 7 or 8.
If it's still in order, does that mean I may have torn it apart? Is that what you're telling me?
Potentially.
I'll find it here. It's probably the last page. I think I saw it somewhere in here. And military affidavit. I got everything here.
It's typically right after the military F.
Yeah. See, for some reason, we get all these statements that are attached too. As usual, I can find it right off the bat. And analysis ones and I can.
If needed, I can email.
Do you have the figures in front of the court costs?
I do.
What do you have?
Filing fee of $75.
Okay.
Motion fee of $20.
Okay.
Service fee of $58.68.
68.
Total is $153.68. Add that to the damages amount referenced, and total balance is $2,503.33.
Okay. Oh, here, and when I found it right at the end. There it is. I do have the proposed judgment showing the amount I asked for damages originally, the total on February 17th, $2,349.65, plus the court cost is just recited for a total of $2,503.33. Judgment for plaintiff in that amount based on summary disposition. MCR 2.11610. I'll sign that proposed judgment and send both of you a copy. Okay.
Thank you all.
All right. Good luck to both of you.
I object, Your Honor.
Okay.
I'd like to make a comment that you're making a judgment based on no contract. All the 6 requirements of a contract were not met. I came to the realization that there was no consideration and no risk and not full disclosure. And you're still going to judge against that without a contract?
I'm not taking questions, sir. You can put your statement on. Is there anything else?
I let my paperwork stand again, and I will have to file for an appeal under Article 10 of the Constitution. This controversy is greater than $25. I will be filing in the Court of Appeal.
Leave it at that, and I've signed the summary disposition judgment I just ordered, and we're all set. Good luck to both of you. Okay, bye.
Rod.
Well, guys, we've come to the end of this proceeding for Mr. John Hayes. And as we can see, Judge Goggins handled the situation well. He was even a little playful with Mr. Hayes, I believe, in the beginning when he was acting kind of ignorant to what he was saying about the bankruptcy. But when it was all said and done, everything Mr. Hayes said in the courtroom, to me, it just screamed, I don't want to be held accountable for this debt. But as we can see, Judge Goggins judged on the plaintiff's behalf in their favor, giving them the summary deposition. And we see that Mr. Hayes owes about $2,500 when it was all said and done, with the debt that he owed, the court costs, the motion fees, and so on and so forth, service fees. But it pretty much went how I think we all thought it would go once we started hearing Mr. Hayes talk and hearing the attorney on the plaintiff's behalf talk. So, I don't think it was no surprise to anyone. But I thank you guys for joining me as always. Like I said, I'm out here working, trying to get things done, but also trying to get these videos out to you. So I appreciate you guys. If you like, share, subscribe, comment, all of those things help the channel and the algorithm. This is Sovereign Citizens Hall of Fame, guys. I can't wait to see you on the next one. And with that being said, Sovereign Citizens Court is adjourned. Thank you guys, and God bless.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.